All right, guys, I got some breaking news for you. Now, this broke a couple hours ago. I saw it on Facebook coming out of the CCDL, so I wanted to do a little research before I brought it to you. Well, here it is. All right, so last month I did a video talking about how a Connecticut assault weapon ban / mag case was heading to the Supreme Court, and it was coming out of South Carolina. Now, many of you in the comment section were naysayers, saying nothing's ever going to happen. And fast forward, we are sitting now at November 10th, which is the Marine Corps birthday. Happy 250th, my little crane eaters. And I had pulled down actually the Supreme Court's, the brief that they're using to the Supreme Court asking for cert. And this morning, I also saw that Grant v. Lamont is now heading to the Supreme Court also. So that's a second case dealing with Connecticut's assault weapon / magazine ban. Now, I reached out immediately to Eddie, who is Eddie Grant, the Grant part of this lawsuit. And I asked him, hey, do you have the brief so I can do a video on it? And unfortunately, he did not have a brief. He heard about it through secondhand. So with a little bit of digging, I was actually able to bring it up. All right, so outside of talking about Grant v. Lamont, this particular case right here, the first one we had talked about, is actually Flanagan versus Lamont. And this is coming out from Gun Owners of America, Gun Owners Foundation, the Gun Owners of California, the Coalition of New Jersey Firearm Owners, Tennessee Firearms Association, Tennessee Firearms Foundation, Virginia Citizens Defense League, Virginia Citizens Defense Foundation, America's Future, U.S. Constitutional Legal Defense Fund, and Conservative Legal Defense and Education Fund in support of the petitioners. This has nothing to do with the CCDL. Now, me personally, I was holding on to this. I was going to discuss it in a upcoming video, but we're going to discuss about it right now. I was wondering, where's the CCDL in all this? Because I told you in the last video that case has nothing to do with the CCDL. Now, GOA, SAF, and a bunch of other foundations out there and groups have done a really, really good job at legal battles across the nation. Now, I always felt like Connecticut was just like the forgotten little stepchild. CCDL, I'm not going to beat them up too bad. They do their best. They just really suck at communicating sometimes. So this particular suit that is going to the Supreme Court has nothing to do with the CCDL. What was their summary? So their statement of the case. I'm just going to read a snippet. I will do my best to have this down in the description below for you to read on your own. It says, in 1993, Connecticut joined a small minority of states in banning the possession of so-called assault weapons, a term used to describe popular semi-automatic rifles like AR-15s, AK-47s, and their derivatives. These firearms are both widely legal and bought by many ordinary consumers. And it lists a bunch of cases. Even more common are the ammunition magazines sold with these weapons, which feature standard capacity of 30 rounds or more. It says, see the petition appendix. And they discuss a whole bunch of things. It's like really good stuff in here. But I want to get to the summary of the argument. The summary of the argument is yet another circuit has ruled that the Second Amendment simply has nothing to say about a ban on the most popular rifle in the country and millions of standard ammunition magazines sold with it. The conclusion is obviously atextual and ahistorical, so they're talking about Bruen here, where you have to go by history, text, and tradition. Yet it's representative of the lower court's continued rebellion against original meaning. This is coming down to the second sort of court of appeals where we had Grant v. Lamont, and we were trying to get the assault weapons ban and the mag ban here in Connecticut basically put on hold while everything works its way through the courts. And the state of Connecticut literally argued that they deemed AR-15s and large capacity magazines dangerous or unusual, which is an abomination when it comes to Bruen. It's supposed to be dangerous and unusual. So they just flagrantly misinterpreted everything and just threw in their own word. It is not or. The opinion below also marks a broader problem with the lower court's administration of Heller and Bruen. They believe history supports broad possessory bans on supposedly dangerous and unusual firearms and accessories, which it does not. So this right here, this case right here, was the first one we talked about. But here's the breaking news. I saw on Facebook, Grant v. Lamont was heading to the Supreme Court. It had finally made its way through the damn courts here in Connecticut. Now, the CCDL just announced it on their Facebook page and said, hey, great news, guys. Grant v. Lamont's going to the Supreme Court to be heard for cert. Doesn't mean it's been picked up. It just means they're going to present it to the Supreme Court. Maybe they'll pick it up. Maybe they won't. I don't know. Lately, the Supreme Court has been absolutely cowards when it comes to the Second Amendment or anything dealing with assault weapons. The assault weapons. Don't beat me up in the comments, guys. I know they're not real. It's the state's definition. It's an actual term they have embedded in these unconstitutional laws. But the CCDL made a post and said, hey, this is happening. And that was it. There was no briefing. There was no further information on it. And when I reached out to Eddie to try and get his information, he unfortunately had nothing. So with a quick cursory search, went to the Second Amendment Foundation, and this came out today. It says, SAF seeks Supreme Court review in Connecticut assault weapons ban case. It's coming out of Bellevue, Washington, which is where the Second Amendment Foundation is. The Second Amendment Foundation and its partners have petitioned the U.S. Supreme Court for review in Grant v. Ravella, SAF's challenge to Connecticut's so-called assault weapons ban. Connecticut is on the minority list of states that have banned both by name and by feature set commonly owned contemporary semi-automatic rifles as part of SAF's nationwide initiatives to put an end to these types of unconstitutional arm bans. The organization filed suit on the grounds that the law violated the Second and 14th Amendments after a troubling, misguided preliminary injunction decision from the Second Circuit Court of Appeals in August. SAF is now presenting the case to the Supreme Court for its consideration. Grant joins 3 other SAF cases currently before the court, including Vermont's SAF's challenge to the Cook County, Illinois assault weapons ban. Last term, Justice Kavanaugh said that he suspected that the court would take up an assault weapon issue in the next term or two, said SAF Executive Director Adam Kraut. Our goal as a leader in the Second Amendment advocacy space is to build and present every possible opportunity for the court to do exactly that. Bans like Connecticut's are in direct contradiction to the demands of the Constitution and prior Supreme Court decisions, and it is time they're regulated to the dustbin of history. As noted in the petition, Connecticut's ban on assault weapons extends to many ordinary and common semi-automatic firearms, including the AR-15 rifle. These covered firearms are mechanically and functionally identical to every other semi-automatic firearm in the way that they fire. Originally filed in 2022, SAF is joined in this case by the CCDL and 3 private citizens. This case has far-reaching implications for the entire country, said SAF founder and executive vice president Alan Gottlieb. Residents of Connecticut and the other 10 states have similar laws that face felony prosecution for owning any number of firearms that are in common use around the country. The Constitution protects all arms in common use by citizens for lawful purposes, even those that activist lawmakers have lumped into artificially conjured definitions based on feature that they don't even understand. So this is the press release from SAF, which came out today. So not only is Flanagan v. Lamont, this case, which is the first one we had talked about all the way back in the early days of October, but now we have Grant v. Ravella going before the Supreme Court. So listen, again, it's a huge win to say the least. Now, I wish the CCL was really better at communicating things, because at least SAF put something out, and CCL couldn't even put this link in their damn post. I don't know what's going on with the guys over there and the girls, but they really, really, really suck at communicating. And I know they always toe the line of, we don't discuss ongoing litigation. We don't want to play our hands. The problem is you're doing these things and you're not telling the membership where we are with it. What's going? Is there nothing? Has it stalled? What are the arguments? What are the lawyers saying? You need to help communicate what's going on with us, guys. Good God, that's my biggest frustration with the CCDL. And I'm a member. They don't communicate. At least GOA, SAF, the Second Amendment Foundation, all these other gun groups literally do communicate on a daily, if not weekly basis with people. CCDL, once a month they do a meeting. They give their little updates. Very rarely do they discuss any cases, and the people really want to know. And that's why I'm here. I'm bringing it to you. So we got to see how this all plays out. I have hope, but like you, I am somewhat black-pilled. I'm really hoping the Supreme Court stops being cowards and gets off their rear ends and picks one of these cases up, whether it be Grant v. Ravella, whether it's Flanagan v. Lamont. I don't care. It's ours or Illinois or the one that's coming out of California. One of these is going to get picked up, I hope, and hopefully the Supreme Court will set the record straight once and for all, and thus our stupid made-up assault weapon ban and arbitrary 10-round magazine law will go away once and for all, and then we will be free once again to purchase the most popular sporting rifle in the country and standard capacity magazines. But you guys let me know what you think down in the comment section. Am I just putting my faith in something that's probably going to go nowhere? I don't know. You tell me. But hey, listen, if you've made it this far, I really do appreciate sticking around for the entire video. Down in the description below is always a link to the merch store. Please like and share this video. If you haven't already subscribed to the channel, please subscribe to the channel. Toggle that notification bell, ensuring that you always get updated when I put out a new video or do one of my Saturday Night Lives. Listen, this channel, guys, is a great way to keep yourself from going from a law-abiding citizen to a felon overnight, because the way Connecticut changes their damn gun laws, it's mind-boggling. And I know, like, a lot of people out there don't pay attention to all the different things that are going on. I don't really expect you to. That's why I'm here doing it for you. So I appreciate you guys making it this far. Listen, let's have hope. Let's hope that it goes somewhere, like in a positive direction. All right? All right, I'll see you guys in the next video.